There is a total shift in the battle of Mazi Nnamdi Kanu versus the federal government of Nigeria. The more Justice James Omotosho presses hard to deny the evidence of the extraordinary rendition and adoption of Mazi Nnamdi Kanu from Kenya, the more the problem compounds. Now, the attorney to Mazi Nnamdi Kanu from the U.S., Bruce Penn, have written to James Omotosho expressly demanding dismissal of the charges against his client, the leader of the indigenous people of Biafra, Mazi Nnamdi Kanu, on the basis of lacking jurisdiction. Now, that is the next hurdle for Justice James Omotosho to cross, which will be practically impossible to deny the extraordinary rendition of Mazi Nnamdi Kanu. This is the latest hurdle that has stopped the continued trial of Mazi Nnamdi Kanu, establish or justify the fact that Mazi Nnamdi Kanu was not extraditioned from Kenya. I believe strongly he will not jump over this to continue the trial. The lead counsel to Mazi Nnamdi Kanu, the U.S. lawyer, has expressly briefed James Omotosho through writing to immediately discharge, dismiss whatever intention he has, whether it's been influenced by the FG and the rest of them. One thing is certain, that this case will no longer continue. For lacking jurisdiction, James Omotosho has no jurisdictional competence or rights to preside over the case of someone extraordinary rendition by the federal government. I hope James Omotosho should not wait to be interpreted what that means. That is the end of the road. Dismiss the charges against Mazi Nnamdi Kanu for lacking jurisdiction or face international courts. That would be the way forward. If you argue that you have the jurisdiction to try Mazi Nnamdi Kanu after violating international laws, bordering on extradition and a multiple violation of his fundamental right, now it is an opening door to international litigations. It will no longer be based within the Nigerian legal confines, because it is a international criminal law. Abducting or kidnapping someone without due process, you have already lost the legal right to continue his trial, including James Omotosho. That is the way to go. And if James Omotosho is a practicing lawyer and judge in Nigeria, he should be conversant with international laws and treaties, which have been breached as far as Mazi Nnamdi Kanu case is concerned. And he should also be aware of the international consequences and implication to such. So, daring to continue with this trial means he is inviting certain international sanctions, both to his profession and possibly against the federal government. Because even the UN working group in charge of arbitral abuse of people's fundamental rights has written to the Nigerian government, giving them ultimatum of 6 months, 180 days, to release and discharge Mazi Nnamdi Kanu unconditionally. That his right was violated. And ever since, he has been detained and incarcerated with intention to keep him there as long as they so desire, without recourse to the provisions of the law. which they happen to be a signatory to. I mean, international laws and conventions, treaties that defines their boundaries and limitations as far as the breach to fundamental human rights. And a man could not be detained more than 15 days without instituting trial. And the provisions of the Nigerian constitutions clearly stated that an accused should be tried within a reasonable time frame. Is 5 years going to 6 years a reasonable time frame? For over a decade, Mazi Nnamdi Kanu has been subjected to endless trial, even when the appellate court of law has vindicated him, squashed all the Trump charges bordering on treason, terrorism, and the rest of it, was dismissed by an appellate court of law of competent jurisdiction and cited clearly that on the basis of his extraordinary rendition, which was recognized by an appellate court of law within the Nigerian legal jurisprudence. Now, how comes that James Omotosho is denying the evidence of his extraordinary rendition? This is made it very culpable and suspicious. The appeal court ruled their case that on the basis of his extraordinary renditions, which his right was violated, grossly violated, that no other court of law within the Nigerian legal system has the jurisdiction to continue his trial. And as such, he was discharged and acquitted. Here we are today. The steps taken now by Brufen, Mazi Nnamdi Kanu's U.S. lawyer, is a welcome development. There's no longer time to waste. There's no longer time to engage in the endless arguments and babbling and the rest of them. He have written demanding for dismissal of the charges for lacking jurisdiction. Possibly will take the next line of action by filing a suit, a case with the Nigerian government and the international courts. Because these are international infringements and violations. Possibly there is no other court within the Nigerian state that should entertain Mazi Nnamdi Kanu case, because it's a breach of international laws, and which is considered a very grave criminal consequences and implications. No wonder Mazi Nnamdi Kanu, having reviewed his case file, said there are no valid charges against me. All the charges resurrected were the ones struck out by an appellate court of law, higher than the jurisdiction of the High Court. The appeal court is far higher, and they cannot give and establish a verdict, rule a verdict, and the lower court will now reverse that. It's not possible. Well, I would have expected the lead counsels to Mazi Nnamdi Kanu to have taken these steps ab initio, insisting that the government of Nigeria has no jurisdiction to try Mazi Nnamdi Kanu and eventually file a case and join suit with other people involved in his detention, torture, extraordinary renditions, and whatever pain he has suffered unjustly. I should have expected them to have done the needful. Of course, and majority of the audience and those interested in this case should have wished so, or expressed the same opinion like myself, but sadly that wasn't the case. But purposely, supposedly they may have done that with purpose, And this is the time, of course, to take the next line of action. For James Omotosho to continue the trial of Mazi Nnamdi Kanu, he should, first of all, establish how was Mazi Nnamdi Kanu smuggled into the country. Was his fundamental human rights grossly violated? Was the extradition process duly observed and followed? Of course, the Kenyan High Court has also confirmed that his extraordinary rendition or adoption was illegal, unlawful, and a multiple gross violation to his fundamental right. So it's a testament standing against the federal government of Nigeria. So what else do we need to hear? Or what is the interest of James Omotosho? Or continue the trial, insisting that the High Court has the jurisdiction, having been assigned by the Supreme Court. Now, does the court stand against itself? The Supreme Court never said that the verdict of the appeal court, which is the highest court, appellate court of law, is not valid. Whatever happened there will be considered as misinterpretation or misrepresentation of the substance of justice. Now it has gotten to the point that nobody could have confidence. Majority of people no longer have confidence in James Omotosho, when that is their personal opinion, and they have the right to express such. And Mazi Nnamdi Kanu, if considers the continued presiding of Justice James Omotosho as a threat to his cause of justice, might disqualify him or ask him to recuse himself. He can't insist that he has the jurisdiction while there are evidence and concrete overwhelming evidence to that fact. So Mazi Nnamdi Kanu might ask him to recuse himself, to disqualify him, that he has no confidence in his dispensation of justice. Well, that may be another way of keeping him incarcerated endlessly. I may not subscribe to that, but if that becomes necessary, he has the right, and possibly filing a case at the International Criminal Court might be the last resort or option Mazi Nnamdi Kanu might opt for, especially now that he have refused to enter defense on a very solid point. He could tender his evidences both internationally and locally, ruling and verdict that was given in his favor. And based on these premises, there's no need to continue the trial, because you can't resurrect a case that is already dead. Ruling has been given, unchallenged, at the appeal court, the appellate court of law. Did you get it now? That is just the QED. Now, I should expect Bruce Feng to match words with actions, and eventually define a pathway how this will go. And I expected Mazi Nnamdi Kanu lead counsel to have exploited these options and possibly setting the pace for the cause of justice. And if the federal government definitely will defend actions at the International Criminal Court, at the International Court, that would be a good one and a very interesting one to watch. So hopefully, of course, we are aware that the case has been adjourned to 4th of November, 4th, 5th, 6th of November, whatever be the case. I hope before then that Mazen Nnamdi Kanu or his legal counsel might definitely file a case at the International Criminal Court to continue his pursuit for justice. What do you think about that? If in case you're watching us for the first time, thanks for watching. Kindly like, share, and subscribe to this channel. Turn on the notification buttons so they can get our videos once it's been uploaded. You can also, of course, express your own opinions via the comment section. Now, let's get back to this discussion. It appears, by my own observation, or based on my own analysis, it appears that by the way things are going, it appears that Justice James Omotosho is working very hard to get Mazen Nnamdi Kanu convicted. With the recent statement that he should consult international lawyers over the implication of his actions for not entering defense and the rest of them, it seems they are laying ambush against Mazen Nnamdi Kanu should he enter defense, and eventually with the window of 6 days that was ordered by Justice Omotosho, what do you expect to do? It means there is a technical ambush or whatever being orchestrated against Mazen Nnamdi Kanu, but they never thought it would backfire to this point that Mazen Nnamdi Kanu haven't understood what is playing out, decided to spring surprises. It was a very shock that he never played into their scripts. He unscripted, of course, the entire scenario, and it was a very, very shocking development that prompted even the presiding judge to make such comments. Good for me, I did not consider as an advice. For me, it's an imposition, not recognizing the right of Mazen Nnamdi Kanu to defend himself. And the decision not to enter defense was well advised, well informed. Because Nigerian laws are not different. They are the same. And the verdict ruled by an appellate court of law cannot be set aside by the lower courts. What James Omotosho should have done is to review the position of Mazen Nnamdi Kanu for taking a decision not to enter defense on the basis that there are no valid charges against him. James Omotosho should have gone back to review the submission of evidence tendered by the prosecuting counsels. Have they been able to argue their case beyond reasonable doubts? Is there any substance of justice or evidence established against Mazen Nnamdi Kanu by the prosecuting counsel? Of course, there was no basis to uphold the 7 count charges against him. which are part of the 15 count charges that was quashed, set aside? Or is James Omotosho telling the world that is more brainy, more intelligent, more brilliant than the emeritus justice, sixth panel of justice that was set up to review at the appeal court, not even at the lower court, to review the case of Mazi Nnamdi Kanu, and came up with such substantive, overwhelming verdict, even in the face of threat and pressure. It was well articulated and presented. So, no, there are more questions and more, of course, findings to unravel. Why the insistence of James Omotosho to continue Mazi Nnamdi Kanu trial? What is playing out? Of course, people are watching closely. From the moment he took up that case, he presided over the case up to now, more than 8 months. And you are giving somebody who should defend his innocency, and you brought him to the tight corner and give him 6 days to defend himself, to put up defense. His defense are the valid ruling that was given on the 13th of October 2022. The records are there. And will ever speak for him. The ruling by the Kenyan High Court is a testament that indeed that his extraordinary rendition was illegal and unlawful. It contravenes international laws and treaties. So what other evidence or defense did James Omotosho really want Mazi Nnamdi Kanu to do? Or to be talking cock and book stories and the rest of it? The first hurdle, as I maintain ab initio, establish his extraordinary rendition. Establish that you have jurisdiction over a man who was abducted, kidnapped, and extraordinary rendition, and you want to try him. James Omotosho want to try and convict Mazi Nnamdi Kanu. Let's have your own take in this.